So I'd like to welcome you all here this evening. Welcome to the Asser Institute. Welcome to you here and also those of us joining online. My name is James Patrick Sexton and I am a PhD researcher here at the Asser Institute and also at the University of Amsterdam. And so it's my pleasure to welcome you here this evening for this event, which is entitled The Register of Damage for Ukraine Towards Reparation for Victims. So we have a really excellent lineup of speakers this evening, who I will introduce shortly. But first I will do a quick introduction to the lecture. So tonight's lecture is part of the Supranational Criminal Law Lecture Series, which is a lecture series on international criminal law established in 2003 by the Asser Institute in collaboration with the Leiden University, as well as the Coalition for the International Criminal Courts. And this event also takes place within the context of the International Humanitarian and Criminal Law Platform. And this is a network of Belgian and Dutch academics working on these areas, which was established in 2010 and is also coordinated by the Asser Institute. So I would like to thank the Ukrainian Embassy in the Netherlands for their support in this event and being our co-organizers this evening. And I would also like to warmly welcome some of our Ukrainian participants from a training we're holding this week at the Asser Institute, and they're receiving interpretation this evening, just to give you a heads up. So tonight we will hear from 4 expert speakers, including our keynote speaker. And after their presentations, we will move to a Q&A session. So I would ask that you keep your very good questions until the end. I should mention that this lecture is being recorded and will be uploaded to our YouTube channel shortly after the lecture. So without further ado, I would like to introduce all of our speakers before handing over to Markiyan for the keynote presentation. So our first and keynote presentation will be provided by Markiyan Kliuchkovskyi, who is the Executive Director of the Register of Damage caused by the aggression of the Russian Federation against Ukraine. And he was appointed on 1st of July 2023 to this position after being designated by the Conference of Participants at its first meeting. And Markiyan has almost 20 years of experience of legal practice in the fields of international law and dispute resolution, during which he has earned recognition as one of the top Ukrainian lawyers in the field. One of the top. And so after Markiyan's keynote presentation, we're very happy to have Dr. Kushtrim Istrefi, who is an assistant professor of human rights at Utrecht University and a substitute member of the Venice Commission. And his expertise lies within the intersection of the European Convention of Human Rights with international law and security. And next to his academic work, Kushtrim has advised states and non-state actors and litigated on issues relating to peace, human rights, and international law. And so after Dr. Kushtrim Istrefi, we will have Victoria Kerr, and she is a Scottish solicitor and consultant to the T.M.C. Asser Institute, as well as REDRESS. So here at the Asser Institute, Victoria works on the Matra Ukraine project, which is entitled Strengthening Ukraine's Capacity to Investigate and Prosecute International Crimes. And she also works on the Restoring Dignity and Justice project. And both of these projects support Ukrainian actors involved with the prosecution and adjudication of international crimes. And last, but by no means least, we have Olesia Zaiets, who is a legal professional with a background in international law. And she currently works as a project officer at the Ukraine Legal Network within the Nahanovich Foundation of the University of Amsterdam. And she has extensive experience in governmental roles, including the Ministry of Foreign Affairs of Ukraine, and has worked with prominent European and international institutions such as Eurojust. So I'm now done with the introductions, and I'm very happy to pass over to our keynote presenter, Markiyan. And you can either present here or there, it's up to you.
Good evening, ladies and gentlemen. It's a pleasure to be here tonight. Thank you to the Asser Institute and the Ukrainian Embassy in The Hague for organizing this important event. on a very important topic, even though I am definitely biased on this point. I'm very glad to see a lot of familiar faces in this room, which puts extra pressure on me because now I know that if I do not do well, I have nowhere to run. But on a more serious note, this is an important topic and something that hopefully will remain a topic for discussion for a little bit of time, because the issue of reparations is never a quick one, never a fast one, if it is successful. Reparation projects only fail quickly. If they are successful, they are long-term projects. And it is our job to make sure that this reparation project, the project that is meant to provide reparation to the many, many, many victims in Ukraine of this horrible war, is successful, and we tick all the boxes in our mandate that is growing by the day. The best way to start talking about the register of damage is to think about it as probably the biggest practical meeting of minds of states on the issue of accountability for violation of international law in the past 75 years. 44 participants and associate members, 43 states in the European Union comprise the membership of the Register of Damage. It did not just came to be out of thin air. It was preceded by fairly quick but nevertheless painstaking work by Ukraine to build a coalition not only around the issue of protection and defense of the principles of international law, but also around the issue of accountability for violations of international law. And it is not appropriate to look at the Register of Damage separately as its own entity. It is more appropriate to look at it as only as a component of a future comprehensive compensation mechanism, because the register is in many ways just a database, and it doesn't make sense without what should come faster, because recording damage is one thing, but then what do we do with it is a completely different question, and we'll get to that a little bit later in a few minutes. So I have a little bit of a complaint against the organizers of this event, because that question mark at the end of the title of this event is not really right, because there's no question about it. The Register of Damage is part of the path towards reparation for Ukraine, at least as far as international law is concerned. The concept of the Register of Damage as part of the compensation mechanism was first reflected in the resolution of the UN General Assembly that was adopted on the 14th of November 2022, Furtherance of Remedy and Reparation for Aggression against Ukraine. It was supported by 94 states, also not a small number by any means. That UNGA resolution, it's very short. It's a fascinatingly short document. It's just a page and a half. And it concludes just three very important points. Point number one, which is more or less a reflection of black letter law, is that Russia must be held to account for its aggression against Ukraine. And by being held to account, it means that Russia must pay reparation for the damage, loss, and injury it is causing to Ukraine and Ukrainians. Point number two is that there must be a mechanism for reparation for the violations of international law and damage, loss, and injury that Russia is causing. And point number three, as a first step in that process, there is a recommendation to establish the Register of Damage. Looking into that resolution, it's not only about these 3 points, however, it's also about definition of the scope of the mandate of that international compensation mechanism that the UNGA resolution is talking about. It is about its subject matter, because the UNGA resolution refers to damage, loss, and injury caused by all internationally wrongful acts of Russia in or against Ukraine, including an act of aggression against Ukraine in violation of the UN Charter, violations of international humanitarian law, violations of human rights law, and others, so among others. So that really defines the breadth of the mandate of that institution, that future institution, I should say, and of the Register of Damage as its first component. So the restrictions on the mandate of the Register of Damage to record, to create a record of what is happening in Ukraine from the point of view of damage is only limited by its statute. And the limitations, the restrictions on the mandate are imposed effectively by 3 key eligibility criteria that claims must correspond to be eligible for recording in the register. One is territoriality. The register only deals with damage that is incurred in the territory of Ukraine. Now, importantly, that territory includes temporarily occupied pieces of Ukraine, including the Crimea, the Donbass, so the areas that had been under the occupation since 2014, and the territorial waters of Ukraine. Temporality, and this is maybe a little bit in logical conflict with item number one, is that register only deals with the damage that's been incurred on or after 24th of February 2022. So one of the questions that we get all the time is why not include the events after 2014 when Crimea and the east of Ukraine were occupied? The answer to that is quite simple, because unfortunately, and I emphasize that, unfortunately, global community did not recognize the events of 2014 as an act of aggression against Ukraine. And it is that recognition of an act of aggression by the General Assembly in March 2022 that now serves as the basis for all other accountability action. And it is very difficult to overestimate the value of that recognition, considering that the Security Council, the main body that must oversee peace and security in the world, is effectively paralyzed by Russian veto. The third criteria, eligibility criteria, is causality. So the register deals with the damage that is caused by Russia's violations of international law in Ukraine. Causality is not defined further. We have multiple instances where practice of other reparations mechanism and claims program determines or defines causality through its practice. And in many ways, imposing an artificial definition on causality is a futile exercise, because in the end of the day, it always comes down to drawing a line in the sand. What is considered to be caused by something and what is not. So this is something that we are yet to fully understand what it is through our work and through our practice. So the register is, depending on where you count its birthday, the register is either a year old or just under a year old. But in that year, we took our very first, very important steps. We have completed our institutional design. We have our conference of participants consisting of 43 states in the European Union. We have our board comprised of 7 world-class experts of international law, reparation, and dispute resolution. We have our secretariat, a small team of 11 people that is punching way above its weight class. And size, I should say. And we have the beginnings of our formal and technical frameworks. We have adopted rules, we have adopted procedures, we have adopted a list of categories of claim, and we are beginning to build, or quite successfully build, the first components of our technical systems. To complete the historic overview, just under 2 months ago, on the 2nd of April, here in The Hague, we announced the opening of our first category of claims for submission of claims. These are the claims about damage and destruction of residential real estate. And to date, we have just under 3,000 claims already submitted to the register. And this number must be seen against the backdrop of it being more or less a beta testing phase, because this is a new system, this is a new concept, everything is built from the scratch. So we're being very careful about making sure that the system works before entertaining the idea of receiving millions of claims. And when I say millions, I'm not exaggerating, because overall we expect between 6 to 8 million claims to be submitted to the register across all the categories, making it by far the biggest claims program that is based on international law in history. And that creates a massive challenge. In the sense of gathering information from 6 million claimants, it could be quite easy to create a simple claim form and to allow the claimants just submit information, create a little form on the website and just submit information in whatever form they deem appropriate. That would, however, take decades to process and make sense out of that. So we have adopted an iterative approach from both formal and technical standpoints. So we are launching things in phases. We've launched one category in April. We'll launch about 10 more in a couple of months, and we'll launch everything else through fall and winter and through April of next year. By April of next year, we will have all 44 of our categories open for submission of claims. At least that's our intention. And hence we are iterating our systems to match this approach. The best way to look, or one of the best ways, maybe I should say, to look about our approach is to see it through the prism of victim-centered approach. This phrase that is familiar to everyone in this room is sometimes difficult to define in a practical sense, because as a general observation, quite literally everything that we do is for the victims, for the benefit of the victims, and keeping in mind the interests of the victims. Individual claims, it's quite obvious, they seek to address the consequences of the war on individuals. Claims for damage and destruction to critical infrastructure, they seek to restore the basic fundamental services that are provided to everybody in Ukraine, including, for example, the provision of power and water supply. Claims for the business losses go towards restoration of a functioning economy in Ukraine, providing employment and business opportunity for the people. Government claims seek to restore public administration and intangible aspects of life in Ukraine. So all that is, of course, part of the victim-centered approach. However, we went a little bit further and thought about how do we actually define it? What are the components of the victim-centered approach for the register of damage? And we came up with an acronym, IPAS, I-P-A-S. It has 4 components, obviously. I stands for inclusivity. That means that our scope of categories are broad as they meant to be. Pretty much everyone and everything who has suffered from this war is included in the scope of the register and can submit their claims. It links to this discussion about the scope of internationally wrongful acts that the register responds to that we discussed a minute ago. And it is on purpose and by design as broad as possible. P stands for participation. The victims get to participate in this process. Nothing is decided against the wishes of the victims or without their participation. Victims get to tell their story through their claims, through their evidence. They get to tell what happened to them, what horrible experience they had lived to, and how their life had been changed by this war. And they have an opportunity to do that every single time they submit a claim. A stands for accessibility. This is a really important one. Everybody can make a claim. The tools are there. Making a claim is not rocket science. It's not rocket science. We're designing our claim form and our claim process in a way that does not require people to seek legal or technical advice about the process of submission. The evidence is accessible or is made accessible to the claimants as much as it is technically and formally possible. Effort is put specifically on placing evidence at the disposal of claimants. Effort is put to the extent possible on avoiding re-traumatization of victims, so relying on evidence that they had given before in other contexts, as opposed to forcing them to give evidence again and reliving the trauma that they had been through. It is also important to understand that accessibility includes the requirement to make sure that the victims, claimants, the people know about the register, what it is, why it functions, and how to work with it. So that means outreach as an important part of our mandate. That means a program to reach out to all our stakeholders, all our claimants, regardless of where they are, whether they're in Ukraine or outside of Ukraine, as so many people are these days, to create a program of informing them, of supporting them, and that cannot be done by our small team. So we are creating this bigger program of cooperation with so many other stakeholders working in this space, both international organizations, well, all international organizations, national authorities, and civil society. For that, we also have our Kyiv office, our people on the ground who are working right there in the field to deal with these issues. And finally, S stands for security. We understand that we are, in submitting the claims, we're asking the people to provide us with the information about the most sensitive and sacred aspects of their lives, about themselves, about their assets, about the horrible experience that they had been through. So we need to understand, we need the people, we need the claimants to understand that their information they're entrusting us with will be handled with utmost discretion at the top level of security and confidentiality. That includes very technical issues related to cybersecurity, because we understand, and people in this town understand, that this is not something that is to be taken for granted in this political and international environment. And we also understand the formal requirements to treat claimants' personal data in an appropriate and responsible way. So all the submission process, all the data handling process is centered on the concept of consent of a claimant to give us their data. We will never receive claimant data from any third parties. We're simply refusing to do that unless there is specific permission to do that. So all the claimant is collected, all the information we are helping the claimants to collect and submit to us. Now, to talk about a little bit about implementation of all these principles in the form of our mandate. There are several elements to it. One, and this is really, really, really important, one of the seminal issues that we have, that we still have, but we already started dealing with that, we have to address, is the determination of evidentiary standards. It is really difficult and really sensitive because we have to strike this very fine balance between what evidence will be required to make a determination about a case, because after all, we are in an evidence-driven legal process, and balance that against what is realistically possible and what can realistically be expected from claimants that deal with evidence on the battlefield. Sometimes dealing with claimants who have no evidence, who had just to leave their home with the backpack on their back, and that's it. So we have to find that really fine balance. That has also a reflection in the way we are designing our claims processing operation. We're not going to analyze individual claims, or at least not only. We are using the big data approach. We now have, I told you the figure about 6 million expected claims. The 3,000 claims that had been already submitted on average have 7 files attached to them. So 6 million claims means 42 million files potentially to deal with. It is, of course, a major technical challenge, but it also is an opportunity because it allows us to do a lot of cross-checking, a lot of cross-referencing, to use a lot of external databases, overall reports, summaries, to find patterns, to find gaps, to find risks, to group these claims together, and then to use tools such as statistical sampling to not have to sift through every individual claim, understanding what it is, and deal with groups in a practical way. Of course, that also means that we can, well, should, can, and probably must use artificial intelligence. This is a massive advantage that we have compared to other systems, to other claims programs. Of course, AI is to a large extent a big unknown. So we are going about it in a very responsible way. In our rules, we have a specific provision that says that there must always be a pair of human eyes that have looked at a claim or a group of claims. So there cannot be a decision taken only by a computer, only by artificial intelligence. And that's really, really important. Now, we also think a little bit forward about what's going to be happening after the register and into the Claims Commission. And it has a lot of different manifestations. One is that we are operating on the assumption that it will be very difficult for individuals to once again submit evidence to us. So we are basically offering them an opportunity to submit everything in one go. When the Claims Commission is established, and I'll get to that in just a moment, and I understand that I'm running out of time a little bit, or maybe already hopelessly out of time, it will be difficult to expect people to submit claims 3 or 5 years from now. Claims, evidence, this is all getting lost in the fog of war. So we have to give them an opportunity and ability to do it now. For legal entities, it's a little bit different because legal entities, as we see it, they have more flexibility, more capacity, and maybe even more need to have another opportunity in the future to complement their claims, to submit their evidence, to make it in a more detailed, do it in a more detailed way. So that is all going into our thinking about the design of the process. Distilled into a single sentence, ultimately, everything that we do is a balance between building a usable database of eligible claims and trying not to prejudice any decisions by a future Claims Commission with what we decide. because it's the Claims Commission that will assign the claims and their substance and award compensation. And as we might be tempted to make these decisions for them, because some claims will be extremely straightforward, we have to stop short of doing that. Now, the Claims Commission is the obvious next big step in this reparation process. This is something that we are already working on together with states. We have an ambitious aim of arriving at an instrument, maybe not concluded, but at least finalized instrument establishing the Claims Commission for Ukraine by the end of this year. The architecture of that Claims Commission, again, is not rocket science. This is something that probably will be inspired by the UNCC, United Nations Claims Commission, but of course it will be an experience enhanced by the benefit of modern technology. It is very important to understand and to remember for us, including that the register is meant to become a part of that Claims Commission. So we have to do everything that we can to prepare that work, to lay the foundation for that work, not only from a point of view of creating a record of eligible claims that will be examined, but also in establishing approaches, principles, and methods of doing that work that will be legitimate, that will be recognized decades from now, and that will leave a mark in the history of international law as a mechanism that was able to address the issue of accountability for the war of aggression. Thank you.
Thank you, Markiyan, for that real insight into the workings of the register. Yeah, and I would now like to pass on to our next speaker, please.
Good evening, everyone. It's a pleasure to be here today, and indeed thanks to the SR Institute and the Embassy of Ukraine for organizing this event. It's really good to see good participation in the room and interest in this important reparation project indeed. I was asked to reflect about the role of the Council of Europe and the European Court of Human Rights with regards to the Register of Damage. So that's also the reason why I will mostly limit my remarks with regards to these two institutions. The Council of Europe has played a leading role in not only setting up the Register of Damage, but also has been the key organization in condemning Russia's aggression against Ukraine and taking a number of initiatives to ensure accountability. Expulsion of Russia is one concrete example of that has been taken shortly after the aggression, holding a separate summit dedicated to accountability, establishing the Register of Damage, and now acting as a platform for creation of the international compensation mechanism and possibly the tribunal on aggression. It is also the key organization right now involved on the most controversial, perhaps, and maybe one of the most important questions, that of what to do with the frozen Russian assets. These initiatives, what I think is important to emphasize, are not only important only for Ukraine, and even though the organization has taken, some may say, bold steps, in practice we see that they have rather only strengthened the organization by focusing on these important initiatives that aim to hold Russia accountable and provide reparation for victims. We see the Council of Europe is being more vital and relevant thanks to these initiatives. Now, I'll touch upon both on the Register of Damage and the international compensation mechanism, as I think everyone is also looking forward to how this will be established. And Markiyan already gave us the plan to see something concrete by the end of this year. So why Council of Europe? And I was thinking when I was asked to speak about the Council of Europe. So why Council of Europe is the lead organization in all this. If you look at the mandate of the organization, one may say there are other more suitable organizations to deal with these issues. Not necessarily that the Council of Europe shouldn't, but there are also other organizations that perhaps could or should have been more involved in this. Now, with regards to the General Assembly, indeed, it was mentioned the resolution that is very important in setting up these three important determinations, including the one on the register of damage. A possible General Assembly initiative to set up the register of damage and possibly also international compensation mechanism could have perhaps ensured a wider participation. While indeed the register of damage is a great success in terms of the numbers of the European states, it is unfortunately too European. I think the world should be more united in responding to the aggression and continuing with the support that they have already initially shown in the General Assembly. I think it is unfortunate that only Japan, United States, and which is the third, and Canada, are the three non-European states participating in the initiative. And the General Assembly could and should have done this. There is also practice on that. The General Assembly had already set up in 2006 the register of damage with regards to the Palestine. That register of damage was set up following the ICJ advisory opinion on the Wall case. Now, despite this, I think it's important to also emphasize some of the positive sides of these initiatives being led by the Council of Europe. Given the rather limited role of General Assembly in this regard and hard to ensure unanimity throughout organizations, Council of Europe has some kind of flexibility in setting up mechanisms that is rather unique for an international organization and can therefore accommodate different, more flexible approaches to ensure an institutional setup that can address issues regarding to aggression, to Russian aggression. First, Council of Europe operates with a 2/3 majority, allowing the Committee of Ministers and the Parliamentary Assembly to take important decisions despite some resistance of member states, because as we know, there are a few Council of Europe member states that are not part of the register of damage. And secondly, it also has an impressive opportunity to establish mechanisms through the so-called partial agreements. Through its statutory opinion of the Committee of Ministers, the Council of Europe has ensured the creation of several partial agreements, one in which I also serve, the Venice Commission, which allows both Council of Europe and non-Council of Europe member states to join initiatives and address issues of international importance. This resolution that I mentioned, 93/28 of 1993, provides the space to ensure, and I quote here, flexible and non-institutionalized arrangements whereby some or all members, as well as non-members of the Council of Europe, may pursue an intergovernmental activity together on an equal footing. I think the register of damage is a good example of this, that has allowed to create this platform, this model to ensure that there is collaboration between states, that there is an institutional house for these accountability mechanisms without necessarily having unanimity within the organization. Also looking at how rather unsuccessful the register of damage with regards to Palestine has been, one wonders whether indeed sometimes a more European or perhaps a regional approach to these matters could be more effective. Now on the international compensation mechanism. So on the 21st of May of this year, the PACE Legal Affairs Committee issued an opinion with regards to aggression against Ukraine. And it emphasizes a list of recommendations as to what should happen. It's interesting, and I quote here that the opinion says that the compensation mechanism should be in principle established under the auspices of the Council of Europe, given that we already have the register of damage, while not excluding other options should they ensure more cross-regional support. I think this already emphasizes both the limitations that exists with regards to rather regional support that we have, but also the opportunity that should there be other options, we see this flexibility of the organization to serve what is needed, but also to leave room for other initiatives should that be possible. Another interesting point from this opinion is that it states that the damages should be covered not only since 2022, the General Assembly resolution, but since February 2014. So it basically asks to modify in a way the mandate of the Register of Damage, which I think is adequate and indeed I think should be the way forward. How much support it will receive, it remains to be seen. But if the number of states remains the one that is in the context of current supporters, I think it would be more adequate to proceed in this way. The other novelty from this is that it emphasizes explicitly that it should cover the damages also caused by the Wagner Group. Now, from an international law standpoint, I think one could have already made an argument that this was already included, but I think it is important that this is mentioned specifically. One of the challenges, perhaps, for the future of the mechanism is related to funding. And this is a big discussion taking place in many parts of many institutions and organizations, as of course, ideally, we would have had a situation where there is the end of the war, where there was a clear winner, of course, Ukraine, and where we would have a post-war situation where the aggressor would apologize and take all the necessary steps to ensure reparations. Unfortunately, that's not possible at the moment. So one aspect that I think is very important, and I'm very glad to see this rather careful approach, both in terms of how you perceive the role of Register of Damage, but also how it should connect to the compensation claims, is, and this brings us to that important notion of the title, the victims. Because setting up a Register of Damage and compensation claim without securing a good budget, a clear budget, may also raise expectations on the side of victims that I think is important to be borne in mind. They are the main beneficiaries of all these mechanisms, certainly also the state, because the damages here include not only those of individuals, but of everyone who has been affected by this war. However, I think it is important that any move on the compensation mechanism is done hand in hand with addressing the issue of funding, as I think this is crucial to ensure that we speak of an adequate reparation mechanism with victims in the center of this idea. Now, one aspect that has been circulating recently is the idea of having the windfall tax with regards to the frozen assets, and the other one to confiscate and repurpose or redirect these frozen assets. I think the answer to this will determine a lot on how also the budget of the compensation mechanism will look like. If it will proceed with a windfall tax, we will speak of a very small budget. It may be still considerable, but we may also expect that this fund will be used both to finance the war and only part of it perhaps for the victims. And if that is then to be raised and the budget is so limited, it will also raise perhaps questions of prioritization. How will the compensation claims mechanism prioritize compensation? Will they give first priority to cases such as rape or issues related to state infrastructure? So it will be very important to bear these issues in mind as we proceed with a mechanism that, even though was raised as a response, as a political response with regards to Russia's aggression, is and will remain as a matter of victims' justice with regards to this war. So I think these are important aspects that will shape the future of the compensation mechanism. Now, very briefly also on the European Court of Human Rights. Also, when I was asked about this, I had to think a bit what shall I say about the European Court of Human Rights? Russia is no longer a party to the Council of Europe. Nevertheless, for a period of 6 months since the expulsion of Russia, there have been a number of important claims submitted against Russia before the European Court of Human Rights. So there is a number of cases that can be addressed. Now, the current Legal Affairs Committee opinion of PACE suggests that the compensation mechanism should also be a place to address enforcement of ECHR basically judgments. So it will be a mechanism through which you may get enforcement of a European Court of Human Rights judgment. And as I was reading that, you see the focus on the ECHR. I was wondering, how does this relate to possible victims' compensations rights through the International Criminal Court, through other types of the aggression tribunal, possibly future cases on investment tribunal, ICJ, and so on. So how will these multiple claims of compensation be addressed through different institutions, and whether the compensation claims will somehow absorb it or will allow forum shopping, or will somehow regulate the process of how one may claim multiple types of compensations in different institutions. So the next thing is the issues pertaining to possible confiscation of these frozen assets may also raise issues before the European Court of Human Rights, in this case, mostly with regards to the Russian oligarchs. Now, however absurd this may sound to many, it may be a situation where it will be difficult to overpass the issues related to property rights of these individuals. So I think it's also important that we have a very safe and sound compensation mechanism, so that there are no hurdles in the process. So I think it's important to address these issues in many ways to ensure that the process will go smooth. One way to do this might be to have some kind of a request for an advisory opinion from the European Court of Human Rights to ensure that we already are on the right direction when it comes to standards of protection on this matter. As otherwise, it may be very disturbing to have a process that is undermined through other institutions. Now, very short concluding remarks that go a bit beyond this dynamic of Council of Europe and the European Court of Human Rights. I think what is very important to emphasize, in my view, and whenever I think of the register of damage, I think of a institution that is not only relevant with regards to direct victims, which, as I said throughout my presentation, are very important, but also to continue political support for Ukraine. So I think it's very important to continue the pressure on the Western states to keep the ball rolling with the register of damage, with a discussion on sanctions, with a tribunal on aggression, as well as the compensation claim. I think if we did not have the register of damage, we would not have had the discussion now on sanctions. So this just shows how important it is to keep the pressure through these accountability mechanisms. So the role of these institutions go beyond that of individual victims. And lastly, the register of damage is also an incredible historic institution, a record that, to my knowledge, cannot be compared to anything up to this date. I don't think there is any war that has had more initiatives to document what is going on and to have a clear price tag for every damage that has taken place so far. So I think this can be used not only with regards to compensation claims, but also with regards to possible other judicial avenues that I mentioned so far, ICJ, investment tribunals, and so on. We already have seen how other cases of aggression has lacked this level of documentation. In Congo versus Uganda case before the International Court of Justice, the ICJ struggled, as did the states, to come up with some kind of rough estimate of what that aggression has costed. So I think it's very important that this work is done for the reasons of direct victims, but also to ensure full accountability for the future of this unlawful and unjust war. Thank you very much.
Thank you very much. I think it was really nice how you zoomed out from the Register of Damage, providing the perspective from the Council of Europe and the European Court of Human Rights. So thank you very much for your presentation. I'm very happy now to pass over to my colleague, Victoria. You can present from here or up there, it's up to you.
Hello, everyone. So as James mentioned, I wear two hats. I work with the Asser Institute on criminal justice in the context of Ukraine, but I also work for REDRESS. And in the context of my work at REDRESS, we are working on financial accountability, so that's asset confiscation, with a view to financing reparation for Ukraine. In the past year, I've been observing how the landscape in terms of reparation for Ukraine and victims of the war has developed. In fact, with REDRESS, we released a briefing on this very topic in December of last year. My contribution today will focus on situating the register among other reparation initiatives in the context of Ukraine, and then providing some reflections. And I'm glad to hear that many of those reflections have already been addressed, but hopefully I can provide some further nuance to those. I should add that while many of these reflections come out of the work that I'm doing with the Asser Institute and REDRESS, I'm speaking in a personal capacity today. In my view, there are many ways we can map the reparation landscape for Ukraine. So for example, is the mechanism a judicial mechanism, administrative mechanism? Is it an international mechanism, a national mechanism, or both? And are we talking about a measure which is reparation in a strict legal sense, or a measure which is not fulfilling a legal obligation to provide reparation per se, but rather has reparative value? And finally, is it a long-term approach, or are we talking about a measure which addresses the immediate consequences of harm? So if we zoom in to the register, first of all, it sits, of course, on the international and administrative levels. And in its current form, as we've heard, it's not providing reparation as such, but rather recording the damage, injury, and loss, which can then feed into the compensation mechanism. Although the register could be argued to already have reparative value in the sense that it's recording the damage and therefore recognizing the victims. But as we've heard, ultimately victims are not going to have tangible assistance through the register overnight, but rather that's the next stage for the compensation mechanism. Bearing in mind that under international law, Russia is liable to pay reparation to Ukraine and victims of human rights violations, it may be that the register and the future compensation mechanism can be seen as the international community in Ukraine stepping in to support victims in ways which have reparative value where or until Russia provides reparation in a strict legal sense. I think the lines are blurred when we discuss asset confiscation, but just to provide a kind of an overview. If we imagine then a map of The Hague, we can cycle across to another mechanism, which I think has only briefly been mentioned, but it's the ICC Trust Fund for Victims. Of course, we have arrest warrants in place at the moment, and those cases could proceed going forward, and the court could award reparations, which the trust fund will implement. And I think my prediction is this is a longer term angle, but the Trust Fund for Victims also has an assistance mandate, and it can provide rehabilitations and support. Unlike reparations under its reparations mandate, the Trust Fund's assistance programs do not require a direct link to an ICC conviction or judicial proceedings. It has expressed an interest and intention in providing an assistance mandate for Ukraine. And I think this has potential shorter term reparative value. Perhaps we can also frame this assistance as reparations in a legal sense. We've heard a lot about the Council of Europe tonight already, but I think it's very interesting how the Council of Europe is straddling the judicial and administrative lines in terms of its support. And I would just also add that it's worth remembering that from the Ukrainian perspective, the European Court of Human Rights is perhaps a more familiar institution to victims on the ground as well, and to civil society. I would also like to mention a specific program which has recently been activated by the Global Survivors Fund, who are working to support 500 Ukrainian survivors, and this is a pilot program, of conflict-related sexual violence through awarding interim reparations this year, including financial, medical, and psychological support. And I add this also because we talked a lot about compensation this evening, but reparation can take multiple forms as well. This concept of interim reparation is very interesting. So it's providing victims with assistance with reparative value urgently while fully fledged reparation programs are established. And that's what the Global Survivors Fund are also working with the Ukrainian government on towards. Moving to Ukraine on a national level, because we've spoken a lot about the international level tonight, Ukraine has not yet developed a comprehensive administrative reparation program. Nonetheless, administrative mechanisms providing compensation to those who've suffered property damage and also to those persons and their family members who've been deprived of personal liberty as a result of the armed aggression and other initiatives have been proposed. Those are in place, but others have been proposed, including in relation to conflict-related sexual violence. These are currently considered as assistance rather than reparations, but they could have reparative value. Currently, the picture is quite fragmented, with many of these forms of assistance falling under different ministries within the government of Ukraine. So Ministry of Social Policy, Ministry of Health, Ministry of Reintegration, among others. There are also national registers in Ukraine, alongside the international register, and those could have reparative value as I described with the international register. Civil society is also very active in Ukraine in terms of working directly with victims, including on applications for compensation on a national level, but also supporting in terms of other short-term needs. They've also been collecting testimonies or stories of victims and documenting harm suffered. There's trust in civil society in Ukraine, and I think this is key. We are fortunate also to be joined by local governance actors this week from Ukraine here in The Hague, and those working at memory centers and other interesting institutions. And we've been hearing about the work that they do, which also has reparative value. For example, in recording and finding truth, including missing persons, and promoting dialogue. There are also judicial avenues, of course, nationally in Ukraine to apply for compensation, and in terms of connecting them to criminal proceedings and also down civil routes. I could go on further, but the point I want to emphasize is how much we've zoomed out from the original pinpoint that is the register. The register is working with and among many other initiatives which could have reparative value in the Ukraine context. And there are many other actors that I have not mentioned this evening, which are not perhaps a mechanism as such, but are already supporting this reparations process. Many arguments which have been raised perhaps as criticisms of the register so far are, in my view, better posed as questions to this broader landscape or broader group of actors to be better resolved as a collective, or to which at least common ground could be found. So I'll pose a few observations and questions, and some of these I think have already been raised, as I mentioned, but I raise them more in the context of this broader landscape rather in relation to the Register or Council of Europe directly. So the first is on, do we have an approach as to what reparation means for Ukraine and victims of the conflict? A very basic question. The scope of all these mechanisms vary. They all have their own independent mandates. So do we have a holistic understanding, also from speaking to victims and survivors directly, of the harms of Ukraine as a state and of victims, which must be addressed in the short and long term? Another aspect of this is assessing whether we're referring to reparation under international law or another de facto definition. I understand in Ukraine, reparation is often understood in the state responsibility sense and also as compensation, which is why we hear often Russia should pay reparation to Ukraine, which is quite right from a legal perspective. I think that the international law on reparations is currently not victim-centered enough yet to make it effective in practice. In the context of international armed conflicts generally, it is very difficult to enforce. So victims are really left in the lurch unless programs are created voluntarily by the national or international communities. It's really a disconnect between international law and practice. So that's why I speak a lot about these measures having reparative value. My second observation or question is, who are the victims with respect to this reparation? Some of this has already been, I think, considered by Markiyan, but I think this is a question that needs to be considered collectively within this group. And just to nuance some of the points that have already been made, are we talking about those with Ukrainian nationality? What about those who no longer have Ukrainian passports? Are we talking about refugees? Do we include combatants as victims? And the most difficult question, do we consider Russians as victims? And even another question, do we consider collaborators as victims? These are not only challenging questions for the register, but for others involved in this space. Markiyan has already spoken a lot about accessibility, and this is definitely a question of outreach, communication to victims, but in addition, as you mentioned, a question of making sure that there is not a requirement to provide unrealistic documentation. This relates to ownership of property, for example, but I understand that on the national level, often applications for victim status require documentation from criminal authorities, including the Secret Service of Ukraine. This is for administrative compensation, not related to criminal charges. So it's definitely important to consider the different levels of proof required. And a question which has already been raised is funding, of course. I understand, and this is a huge part of the work that REDRESS is doing, that there are many questions going on regarding state asset confiscation and asset confiscation of Russian oligarchs. But we find, especially in the UK, and we work with partners in the EU and US and other G7 members as well, that absent from all of the discussions on asset confiscation is channeling these funds into measures which have reparative value. Everything is being channeled into defense, reconstruction, and recovery of Ukraine, which are important, but reparation should also be part of this discussion. These funds could make a massive difference to the operationalization of many of these reparation initiatives. And there was a point, I think, that was made regarding the register of damage, and without the register of damage, we wouldn't be having these conversations on sanctions. If I understood the point correctly, I think I would disagree, because our experience is that government actors are not considering these as channels for where to channel the funds. We've been doing a lot of advocacy work on that, and Markiyan has been part of that as well. So my final observation is just in terms of cooperation between these mechanisms from an international to national level, between national initiatives, and in terms of funding channels and outputs. And a final point that was also raised was in terms of linking criminal justice processes with these administrative processes as well. I do think it's a very interesting question regarding the links between the proposed aggression tribunal and the register of damage, because we could be talking about the same victim pool. In fact, we are talking about the same victim pool. I don't know if enough has been done to consider whether further cooperation between these mechanisms could be useful in terms of streamlining processes. So the register is already tackling a lot of these challenges, but it is not alone. And I think this has already been mentioned, but all of this is being done to support victims of the war. But I still think that the voices of the victims and those working with victims, including Ukrainian civil society, should be at the core. And I mean this also in the design and the operationalization of these initiatives. With such an enormous amount of victims, it is a difficult challenge. And if all the victims were together in one room, would they speak with one voice? I don't know. It would also require expectation management because victims' lives will never be returned to complete normality. But there needs to be a balance. And I think victims can really shape and drive this process more so than has perhaps already been done. I'll stop there. Thank you.
Thank you very much, Victoria, for perhaps zooming out even further and providing a kind of bird's eye view on the entire reparations landscape. So thank you very much. And I think that that connects well to our final presentation. So please, whenever you're ready.
Yeah, it is. So thank you very much for inviting us here. It's I really have a great pleasure to listen all speakers and to have a more entire picture about the mandate of register, what we are discussing now here. And the lecture is indeed very, very important. I'm Olesia and I'm from civil society organization. So I will be speaking more practical. We have heard a lot of theory about mandates, and now I will speak a little bit more about practical issue and challenges that Ukrainian people are facing. So who we are? We are a Ukraine Legal Network, which is a project of Nuhanovich Foundation. We are based in Law Hub in Amsterdam, in its premises, its offices from Amsterdam University. And we are mostly Ukrainian lawyers, advocates, international law, Dutch lawyers, also human rights activists, students, and just people who care about Ukrainians and their problem. Our way is victim priorities, and we every time aim to support them in every questions they have. Victim, and we are calling them here very often survivors. So the main goal is, of course, to chase the justice for Ukrainians, to help them with redress and to see where are problems, gaps, challenges. Our target group, as I mentioned already, are Ukrainians, survivors, people who suffered from war crimes, from human rights violation, who really need to be helped one day. And the majority of people who I met here in the Netherlands, and the community is quite big. It's like 100,000 Ukrainians fled here. Of course, not of them are war crime survivors, but some of them really have a lot of questions because they are in another country. They are without Ukrainian support here, without national system, without investigation teams, language problems. All this we are seeing every day with our Ukrainian community who is here. And our approach, and I'm very happy that it's in line with Markiyan, REDRESS, and with the team of Register, is a victim orientated and victim centered one. So Register and ULN, we will speak from victim-centered approach, from its perspectives. And this is simple words, which we mentioned, and we are speaking about them quite often. But what is standing behind? What is real problem of Ukrainian community? We are speaking about that it should be accessible, it should be transparent, it should be effective in the end, we should have a results. It should be fair from the point of burden of proof. It should be flexible as well. Now I will go a little bit down to the earth. So I will just tell you about few stories that we recently hear during our event, which happened 2 weeks ago. Thank you, James, you were there. And yeah, the people just came there and they immediately voiced their problem. And one of the problem, it's not even a problem, it's a drama, was of a person who said to me, listen, I had a beautiful house in Kherson region, which is now occupied. And it is totally destroyed. I know about it. I saw photos. But when I was fleeing, I lost all my documents. So I don't have any ownership, which are proven here. And unfortunately, the property was by before the digital register of properties was established, which was before 2003. And he didn't know, and he doesn't know if it's still there or not. He's living here, he doesn't have nobody in Ukraine. So he's asking me what I should do. And there is every time ways and solutions. That we just need to be there in the right time, in the proper time to help them. First of all, to create this burden of proof, this proofs, this database, these documents, and in the future, they will be able still to submit their claims. But people need help. They need our consultations. Another story is about ladies. She fled from occupied territory with her brother here to the Netherlands. And she said, my property is not destroyed. It's still there. So basically, technically, I'm still owner of it. But Russians are living there. And my parents are living not far from there. And they are seeing my apartment is already busy with other people living there and using it. I will not come back there. I've lived here. My brother will not come back because he doesn't want now immediately be, exposed to army obligation, etc. What should I do? And what kind of assistance you can advise me? And this is a practical question that people have. And I can tell you here, people who are sitting here, they have a legal background, they have legal education, they are experts. And what we are speaking about statute of register, about regulation, about mandate, how Council of Europe is involved, what categories of claims exist. For us, it's understandable. We can read and understand. Ordinary people, baristas, engineers, people who are just working in an airport, they really need translation of these rules. They need translations of everything which we are speaking now. And this is how we are coming back about civil society organizations and what we can do in this process. I will a little bit speak about the fair and realistic burden of proofs. Again, questions arise if archives are burned or are lost on the place where there will be where there was a war, it was like shelling and a fire. How to fixate the loss? Sometimes you know that your property is destroyed, but you don't know how to prove it because it's in occupied territory. And here we were speaking a little bit about maybe we could and should in the future involve satellite photos or just investigation from OSINT group of open source, publicly open sourced. And to be honest, we had already some talk with OSINT for Ukraine, which is our partner here in the Netherlands, and they are seeing really an avenue how they can help. Just the question how it will work, and this is how we should speak, discuss, and deliver to Ukrainian community. Flexible rules regarding submissions. Here, one thing that we were discussing, it's about how to be with collective claims. Let's see, a big apartment block was destroyed. And all owners lost their apartments because it's already obvious, it's already destroyed. Do we need to go like one by one claims, or there will be a sort of collective claims that, also will be possible? I'm sure all these questions have answers or will have answers one day, but this is something that we need to discuss and to see how we will deal with it. I have many times visited LinkedIn page from Register and Markiyan's also personal, and there are plenty of explanations and guidelines there, and they are brilliant. For me, totally understandable, and I do see they are practical, but again, ordinary people sometimes need a translation, and this translation we can do together by training people, training lawyers, engage them in pilot cases, see claimants problems, see what gaps exist. So this is important, and that's why we are here, and that's why I'm here to speak to you about this. Our other concerns, well, James said no questions, but unfortunately they are here. Well, we can discuss it later as well. And they were already mentioned, so it's not new, and for experts, for people who are in this topic, who are involved, it's something that we discuss every time when thinking about solution. Of course, funds which are directly connected to managing people expectations. When they are coming to you, they are saying, I don't mind to start the claim, I have like everything, but when I will be compensated, is it like a vivid and realistic possibility for me? It's also trust, because some people are living here for 2 years already, being not helped. So all these questions, they are saying, where is the money? How you will pay us? And we need to explain that the money will be there one day. But this is a long and difficult a way, to see how we can do. In the previous event, one of our speakers, it was Ivan Gorodetsky from Istrefi Center, he said, the discussion is there, and it's already a big improvement. There is even national already legislation which are dealing with frozen assets, and as it was mentioned, with redirection of its purpose and compensation in the future. And these two countries, it's USA and Canada. So first two are there already. Why not the rest to join? We need to speak about it, because in the end, it's a justice. It's a justice restoration. It's not about that other policy which is involved there, but it's how to help people and country in total who suffered great loss and damage from this devastating war. The another issue Markiyan also already mentioned, he was very precise and detailed. So there is an assembly resolution, and that's why no cases which occurred before 24 February 2022, cases where people suffered losses and damages, will be considered in this case. I understand, everybody understands this, but there is still rule of law, and there is still a justice. And how to be if there is the same street, and one street was destroyed before 24 February and another one after. So basically your neighbors are entitled, you are still need to see for other possible avenues, which is also could be a national mechanism of compensation in Ukraine. The third one, we also already mentioned, it's about how to synchronize all possible judicial avenue which are dealing with compensation mechanism. And here European Court of Human Rights and its interstate application will also have most probably decision on compensation, which will be very difficult, as it was already mentioned, to enforce, because Russia will not agree, will not compensate, and they will not simply join this process. Sometimes they just don't care about rule of law. So how to be here, how to synchronize all these different compensation mechanism, again, investment tribunals, or it's more like arbitration courts, human rights decisions, national one as well, because there are also on a national level a lot already of claims which we have already awarded decision on compensation. This is issue that we are discussing with our member states, with our lawyers, and we sometimes have some questions that needs to be there, that are waiting for a proper response. Okay, our activity. Well, I think I already mentioned that the main aim of the Ukraine Legal Network is to raise awareness. And this is something which coincides with the people who are here in this room. We need to raise awareness of ordinary people, experts and others, how the register works, how it should be working in a proper way, that it is accessible, that it is transparent for people. And to be honest, after the last hour event, we had an issue that experts came and ordinary people came. And then it was a little bit mix of ordinary people were speaking about their problems and experts were like speaking about more like, developed language. And we decided to create a team of lawyers that we will be training in the future, how to make a claim, how to I think it's time to end. How they will basically lead them how to proceed with the claims to the register. And this is a nice initiative that we will be dealing with the future. And of course, we are analyzing and sharing lesson learned findings. This is, I will go very fast about this slide. So with people is with human being is every time the same. It's a trust and awareness. If you trust somebody, you get there, you are open to dialogue, to see what is happening, to see how it works. And then you are becoming aware. And when you are aware, you get a trust because you have the knowledge already in your head and you know how it works. So this is something that we need to use every time when we are directing Ukrainian community and community in total. It's using right people who are on locations, who are trustful, who can deliver the message, who can spread knowledge. And in the end, we will have the right connections with Ukrainian community who, to be honest, have a sort of research fatigue. What is that? You are living for 2 years in another country, working hard, everything goes so slow. And every time people are asking, so how is it? How you are doing? What you need to have? People sometimes are not open anymore, even to speak about their problems. So we need to have and to use the network that is already existing here in the Netherlands, the network of Ukraine Legal Network with Ukrainian lawyers, experts, people on location, psychologists who are working here, other NGO who are involved. This will connect us with our target group that we are aiming to help. This is my last slide. So soon, your torture will be ended. We are launching a sort of barometer. It's a research which with an expert group which already created, and we will see how people are aware about claim submission process to the register. So it will be conducted, we are now still working a little bit on methodology, but it will be conducted with questionnaires and personal interview online and offline, where we will see what gaps, questions people have. Maybe it will be also my question to register and to Markiyan, how we can make it working, how we can make it more also useful in the future for register to work with the findings, with key findings, because it will be in the end some information that we need to deal and to see how we can ameliorate the process. And all these findings we are of course willing to share, to discuss, to present, to create a nice brainstorming sessions to see how we can help. And let's hope feedback we will have from stakeholders, what steps are taken and how we can help really in the end, people to whom this register and all this mechanism of compensation is created and aimed. Thank you.
Well, thank you, Olesia, for your presentation. And thank you for telling us about the important work of the Ukrainian legal network. And I especially like this idea of translation that you talked about, not just between languages, but within languages, from legal language to something that's understandable by victims, who I think all speakers have said should be the focus of all of these initiatives. So we now have some time for a Q&A. So please raise your hand if you have a question. I would ask you to state your name and affiliation and try to keep the questions short if possible. So do we have any questions? We have a microphone here. So I have one question in the back, and then we'll maybe work towards the front.
Hi, good evening. Thank you everyone for being here. I'm Veronica, Ukrainian, working actually at ASA Institute. I'm curious about victim-centered approach. Can society as a whole be considered as the first one and the main category? Because if an act of aggression happened, if the person or people, family who didn't lose their homes or, yeah, I don't know, any belongings, they're still really impacted. Thanks.
And maybe we can take one more question before we go to the panel. So maybe here.
Good evening. Thank you so much for all the presentations. My name is Christina Parandi. I work at the Dutch peace organization PAX, and I have more technical question about the criteria for submitting claims, but maybe not at this stage for individuals, but for categories where the state is responsible to submit those claims. For instance, we work a lot on environmental damage mapping in Ukraine. That's why it's very interesting to know who develops this criteria. Is it done by unilaterally by Ukraine? Is it also something where Council of Europe plays a role? So probably how data, like how to ensure integrity of data, what are the sources of data, and how the state will go about this. Thank you.
Thank you. So I'll maybe pass over to the panel. Whoever would like to jump in first, feel free. Sorry, could I ask you to use the microphone just so the people online can...
Yeah, it would be also very helpful for us if you are naming the person to whom you are addressing your question. Yeah.
Well, perhaps Markiyan.
Yeah, let me make things easier and answer the question that may be more in my lab about the criteria for government claims on environment, and not only environment but others as well. The simple answer is that all that will be determined by the register of damage, and more specifically by our board. But that's a very simple answer. The more complicated and the more truthful answer is that it will be a result of a painstaking analysis and research on how, on what are the international law bases for these claims, what are the internationally recognized standards for the types of these claims, and what are the recognized standards for the evidence of that claims, for that claims. Thankfully, there's now a lot of practice on environmental claims in these contexts, and perhaps most notably in emanating from UNCC, where environment took sort of perhaps an unexpectedly prominent role after the damage to the Iraqi oil fields and everything that happened in relation to that. And rest assured, and that reflects the approach that we are taking now. That analysis will also include assessment of what realistic evidence can be submitted to us, what is the source of that evidence, and how reliable that evidence can be. As I said, in many ways that represents a forward-looking analysis, because we not only, I mean, as far as we are concerned, the evidence that we require as register is very simple. It's prima facie review, just to tick the boxes on eligibility criteria. But again, we want to create a solid basis for the future claims commission work. And we have to look a little bit ahead and foresee how sort of what evidentiary standard will be applied there, and what evidence can we invite claimants to submit to us or through us that would be recorded there. But again, to make a full loop of my answer, that will be determined by the register, but of course on the basis of international law. This is so maybe I would stop short of calling it unilateral determination, because we are relying on the body of law that's been developed over the past 30, 40 years.
Would any of the other panelists like to jump in also on the first question?
From the perspective of social, civic society foundation, of course, for us, our victim-centered approach is the main. So I mentioned that we have a target group or people with whom we are mostly working, it's survivors. But I know, and I'm pretty aware that there are other NGOs here in the Netherlands that they are working with other questions that Ukrainian people are having there. And it's a much broader scope of problems that they have been helped by other NGOs as well. Our target group is it's survivors. Did I reply to the question, I hope? Thank you.
Yeah, please.
It's a very difficult question, so that's why I think I was also not sure whether I should engage because it's a tough one. The more I'm thinking about it, I think it's a very interesting question, and it deserves indeed more thinking about what constitutes a victim. There's a lot of focus on the damage. So if you look at the list, is the list of what constitutes a damage. But if you think more from a victim standpoint, it may not necessarily fit very easily in one of them, or maybe a combination of things. So I think this is a very innovative, in the end, it's not necessarily innovative in the sense that we haven't had register of damages in the past, but I think we are also more, with the passing of time, all these mechanisms tend to be more inclusive and so on. So I think it could be argued that perhaps other types of damages could be included, but that I think would need more thinking on how do you qualify that. Would loss of profit qualify as a damage? So we're thinking about, for example, property. It was mentioned that someone could not access the property. So does it mean that it needs to be burned down for you to qualify as a victim, even if you can't access it? Or psychological trauma that has a price tag that people can demonstrate, whether because of loss or the constant anguish and fear in which they live in. So I think there is room to at least conceptually discuss these issues and then see whether they can fit in the mandate of the register.
Yes, Victoria, please.
I just want to ask a follow-up question, actually. It's to Markiyan. It just sprung to my mind. When you mention in coming up with the criteria, you mentioned research and analysis and then being informed by the international law and practice on it. What form does the research and analysis take? For example, are there also consultations happening? Are there consultations happening with survivors in determining that criteria? Just because this is what I mean in terms of a victim-centered approach, is involving them kind of from the design stage all the way through to then the application stage.
Again, starting with maybe a simple and short answer, it includes everything. Every resource that we can get our hands on, whether written in an old manuscript or in a word of a testimony of a real world survivor, that is valuable for us. And I realize, and I particularly dislike that about being at the start of the journey, because to many of these questions, my answers are in the future tense. And I dislike that because I like to get things done rather than speaking about them in abstract. But everything that we implement in terms of our rules, our procedures, our claim forms even, is informed by real world. Well, I'll rephrase, is informed by two things: theory behind it and real world in front of it. Because like I said in the beginning of my intervention, it would have been very easy to create a web form that would said, here's a text field, describe your claim, here's a button to attach files that you want. Super easy, but completely meaningless from the point of view of victims. So we actually go to great lengths to absorb that real world experience. Not only, I mean, for me, it's a little bit easier having spent 20 years as a lawyer in Ukraine, but also, you know, wartime Ukraine is a completely different place. So we talk to people, we talk to NGOs, we talk to Ukrainian authorities, we talk to organizations that are working on the ground since before 2022 to understand what are the real challenges, and we try to reflect them in these claim forms. But you know, just to emphasize, this is and must always be an international law-based process. As long as it is international law, we can never be completely lax about evidence. And there will be situations, we will not get around it, where, you know, an individual has a legitimate claim, but simply has no way of establishing even the bare bones of that claim. That individual probably will not be satisfied. And when we're talking about 6 million of potential claimants, there will probably be quite a number of those. Our task is to minimize that number by providing a flexible standard. I actually wanted to mention this in my intervention, and sorry for taking so much time with this answer, but to reflect on a little bit of a difficulty that we are having. So the most comparable claims mechanism to us is the UNCC. UNCC dealt with 2.3 by memory million of claims. One of the big categories of claims was departure. So people that had to leave their homes when the war had started. The panels of commissioners evaluating these claims and evaluating that evidence came to a very straightforward conclusions. Look, they said, our governing council, our political body, has established that these claims will have a capped compensation amount of $2,000. It means that we can be pretty relaxed about evidence required from these people. So as long as there is something that hints on the fact that they were actually displaced, that's enough for us because the compensation is not all that great. We can debate the moral validity of that approach. That's a completely different thing, but that was the approach. What is difficult for us is we do not have that guidance on what the compensation will look like. We have no idea. So we have to, again, be imaginative about it, try to find a balance between what is realistic, but what will be enough to satisfy at least the basic standard of proof in collecting that evidence. But, and I want to assess it because it's really, really important, it does not mean that all the evidence has to come from the claimant. In the case about a house in Kherson, and our sort of standard example is an apartment building in Mariupol, where people may have nothing to prove their title, their anything. It might be enough for them just to submit a claim that this is my house, this is where I live, this is a photo of me in front of that house, here's the address, here's the geographical location. What we can do is then we can look into, for example, database of satellite imagery that shows that on the 21st of February, the house was intact. On the 25th of February, it's completely burned down. There's so many houses in Mariupol. That's all the evidence that we need. And that really does not place too much of a burden on a claimant. Of course, that has to be explained, that has to be elaborated, devil is always in the detail. But again, we have the benefit of technology that can fill some of those evidentiary gaps and help the claimants. Apologies for, for a long answer.
No worries. Do we have any more questions? I think so. One here, and yeah, maybe we can just take maybe 3 questions. So here, I think.
Hi, is this on? My name is Rosalind. I work at the Iran U.S. Claims Tribunal, but that's not my obviously I'm here in a personal capacity. I guess one of the things that's always interested me about the register, so this is aimed at the register, is whether or not there is a mechanism for independent evidence gathering as part of your work. And because I guess one could liken the register to a trial in absentia. And of course, Russian participation would be great. but it's not realistic that they would ever take up a right of reply. And just also hearing you speak about the difficulties of evidence gathering where there's no objective evidence available, it makes me think of refugee law, where often asylum seekers would not have the mechanism to provide evidence of their homosexuality, for example. So that might be an interesting likeness.
Thank you. And I think we had a question here.
Sorry, hi, my name is Donna and I work at Wildlife Justice Commission, so it is not related to this entirely, but I have a question for Victoria about redress, because I did read the report on the assets being frozen from December and it was incredible. So my question was, what are sort of the following steps or initiatives that redress is strategizing to make to perhaps help Ukraine or any other reparative notions? Thank you.
So maybe we can begin with the question for Victoria and then Markiyan and whoever else would like to answer the first question.
Yeah, sure. So at Redress, our Ukraine work on this falls part of a broader team, which is working on financial accountability. So that encompasses asset confiscation specifically with a view to financing reparation. But also innovative avenues to finance reparation. And by that, we mean gathering of funds not through asset confiscation, but through other means. So Kushtrim mentioned windfall tax. We're also looking into the enforcement of ECT, the European Court of Human Rights judgments. We're looking into sanctions enforcement and using penalties from sanctions evasion, for example, to be repurposed. We have a big case on the sale proceeds of Chelsea Football Club that we're looking to repurpose towards reparation for Ukraine. And then the final tranche of our work, so to say, in the Ukraine context is then on the actual delivery of reparation. So working with Ukrainian authorities and some of the mechanisms that I mentioned in my presentation tonight to try and make that link between the asset confiscation and the innovative financing routes and the actual delivery of reparation in practice. We have a lot of activities in the pipeline. In fact, much of my time is being spent on meetings for upcoming strategies at the moment. So yeah, keep your eye out on the work on that.
Thank you, Victoria. And would any of the panelists like to address the first question? Markiyan, yeah. Thank you.
I guess I could do that. So I talked about the independence of evidence gathering and submission in my remarks, but I will detail it in three different ways. One way, just to get it out of the way, this is certainly not something that we as a register can do. Realistically, Ukraine is a big country. Ours is a small team. Even if we had 500 people in our staff, that's just not realistically possible. So that's out of the question for us. Second is, again, this focus on the issue of personal data protection. We have to be absolutely clear and make sure that data that we operate with, that we process, that we store, we have the right to do that. So we have to look into the data protection regimes, including GDPR here, including Ukrainian data protection laws, to have a solid foundation for it. And we made a very conscious decision to focus on the concept of consent of a claim of the owner of that data for transmission and processing. Otherwise, it would have required us to redo the entire system of data protection in Ukraine, at least. So that's number two. That means that all the evidence that comes to us must come from the claimant with very clearly expressed consent by the claimant for provision of that data. Not so much of a problem for claims from legal entities, but clearly for claims coming from individuals. The way to address that a little bit in terms of providing claimants with resources for evidence gathering is by making sure that there are databases of evidence that are placed at the disposal of the claimant, either, which is preferred way for us, through automatic connection to our own databases, or rather to the DIA database, to the DIA system that is used for submission of claims, in the sense that claimant logs into DIA, the claimant can make a query to that database. If there is some information about the claimant in that database, the claimant will receive it back, and then we'll be able to submit that evidence to us. If that is not possible, we can do it in an old-fashioned manual way. For instance, we are in the process of establishing a relationship with one of the UN arms working in Ukraine that have data about tens of thousands of cases that are most difficult for us, evidentially, that are linked to the alleged war crimes. They can share that evidence with claimants as long as claimants ask them. And we work with them to identify in what form, in what format, what scope of data can be provided so that it was realistic for them to handle it and then useful for us in terms of processing it. And then there's a third layer where we can engage with third parties and independent evidence gathering, but that evidence gathering is at a summary level, at a reporting level, as opposed to individual cases level. So we can look at reports of events happening at a certain location at a certain period of time. And that's incredibly helpful because if we, as an example, can understand that, you know, in a certain period of time in the northeast of Kharkiv Oblast, there was constant shelling on a daily basis for 28 days. And there's a claim for destruction of property in that area, but no evidence whatsoever about the causes. That report can allow us to make that connection and support the claim. And same with respect to anything else, and same with respect to all this other information that we can quite creatively, to be honest with you, use. So when we talk about cooperating with international organizations, especially those that investigate these issues in Ukraine, when we talk about cooperating with civil society organizations that do that evidence gathering, interviewing witnesses, interviewing survivors, all that is very relevant as a sort of overarching description rather than as a value for individual cases. But that is really, really important.
So I think we have time maybe for one final question. And I see here you've had your hand up since the start. So we'll have one final question, and then I'll maybe give the speakers 30 seconds if they want to have a kind of final comment, but we'll have the question first, please.
Okay, my name is Angie Garcia Tortua, and I'm working as a criminal investigator for crimes in Ukraine with the organization Project Expedite Justice. And my question is for Markiyan. So I am aware that the cabinet of ministers had issued some resolutions, and particularly the law 2923 that tackles the issues of compensation of real estate property. So I was wondering how the register is working to harmonize those regulations and methodologies that have issued different organisms and ministries of Ukraine in relation to compensation. Thank you.
Yeah, thanks. This is a really great question because it highlights a lot of things that we are generally doing in that sense. Before I answer that, I just want to, maybe that's a personal preference, but I somewhat dislike when people, and that includes the Ukrainian government, uses the word compensation for what they're doing, because that is not compensation. That is aid or assistance that Ukraine is providing to its own citizens where it is needed. So sometimes that line is blurred, and I just want to make it clear that the Ukrainian government has done nothing wrong to those people to compensate anything. It's just lending a helping hand. And that allows us really to work with them, not fearing that we will overstep a boundary or get into their space, because there are fundamentally two things that are very important. One is that we are able to leverage the work that the government does in collecting the information underlining the aid packages, let's call them that way, that it is giving to claimants, including evidence about destruction, evidence about titles, and verification of that evidence by local authorities. That is part of the process. That's exactly why compensation or claims for destruction of residential real estate was the first category that we launched, because we had the luxury of working with an existing database that we could connect to, use, and in many ways model a little bit after. So that encompasses right now about 70,000 cases that have gone through that process. So when I talk about 3,000 submitted to us, that is from the pool of 70,000. So that is of course coming. The other angle of harmonization, let's say, is every time the government is paying that aid to claimants, the claimants assign the portion of a claim to the government so that the government could then pursue it against Russia. And there's a meticulous record of all that. So at some point when we are reaching that point in our technical ability, we will also allow the government to make the claims for compensation. And that is also an additional layer of usefulness to us, because at that point we will be able to match and cross-reference the governmental claims and the individual claims about the same sort of property, to make sure that there's no double compensation, but also that there are no gaps, that nothing falls through the cracks. And to the extent possible, we're trying to replicate that approach in other aspects. So for example, one of the big categories that will launch probably next, that will test us on volume, is the category for internally displaced persons. So there's about 3.5 million people that are in that category, that have been meticulously recorded by the Ministry of Social Policy of Ukraine, that in some instances have received compensation or aid, that we'll be able to use that database as a source of evidence from these claimants that to be submitted to us.
Perfect. So if our speakers have any final remarks, this is optional, you don't have to, but maybe Kushtrim, if you would like to say some words, or if not, then we can move on. I'll come back to you. I'm saving you for the last remarks.
Outside the questions that were raised so far,
Yeah, just key takeaways from.
Yeah, maybe. Well, I will come back perhaps to this issue of compensation mechanism and this transition from register of damage to the compensation mechanism. I think this will be a testing moment for the strength and perspective of this mechanism and the register of damage as well. So I really encourage that this is done very carefully to ensure that there is clear funding in place before the compensation mechanism starts working and creating an expectation on victims that something will be done. I think this is my tip, if I could, on this matter.
Thank you very much. Olesia, do you have any final thoughts, key takeaways?
No, thank you. I just really enjoy, because a lot of very important, pointy, sharp issue and points were voiced here. And I think if we will work properly and we'll take in consideration all these problematic questions, we will find a solution. Thank you.
Well, I think that's a very good key takeaway. Victoria, do you have any last comments?
No, I think the main thing I've also taken away from tonight is this translation point. So from focusing on all these technicalities, which my mind is now buzzing with them, but translating that to victims, and I think also to policymakers and a non-legal audience. As lawyers, I think it can be difficult for us to do that. And I think hearing Olesia explain in that more practical sense is really kind of hit home also to me. I think it's even harder in an academic environment to do that. So I think just reminding ourselves to translate these messages to those who we're ultimately all working for is the main thing I've taken away.
Perfect. And last but not least, Markiyan, please.
Thanks. Of course, I'm going to speak. Dr. David Caron, who spent some of his professional time here in The Hague, has famously said that the UNCC is a tool of practical justice. That's the term that was coined by him, to say that it will never be, things like that can never be a human rights project. The right of any individual victim will never, in that sense, prevail over the right of this over the big picture and the rights of many. Because if in these unusual, unprecedented situation, if we want to assure compensation or reparation for a large group of people, we have to focus on that large group of people. Now we have, it passed 30 years since that quote. So we have the luxury also of, or we have the obligation rather, to also focus on the individual, but finding that balance, that practical balance, is also extremely, extremely important. And somehow this question of very, very well put concept of translation comes up every now and then. But I want to make another iteration of that concept. I don't think we need to translate. I think we need to speak both languages. We need to speak the language that makes sense from point of view of law, that makes sense from the point of view of international law, that will leave a mark there. But we also, not alternatively, but also have to speak in a language that makes sense to the people, because ultimately it's the people who are the users of the system and the beneficiaries of the system. Thanks.
I'd like to invite you all to join me in thanking our speakers for this wonderful evening. So thank you to our speakers for their wonderful insights. Thank you to the Ukrainian Embassy for their support. And thank you to all of you for turning up and asking these wonderful questions. If you're interested in attending future ASER events, please sign up to our newsletter. We're having an event on the 6th of June, which is entitled The Right to Health for Women in Armed Conflict, Addressing International Law's Role in the Humanitarian Crisis in Gaza. I'd also like to thank my colleagues in the events team in the tech room and Konstantina for helping with the microphone. Yeah, thank you for joining and enjoy the rest of your evenings. Thank you.